next speaker is a good friend of mine. Many of you are probably at least know of Jim Driggs, or have met him through law school. He is currently a general law attorney with the law firm of Cawthorn, Deskovich, and Gavin. He attended VMI for his undergraduate degree. He went on to work as a realtor and an associate broker before law school. Then he attended the University of Richmond School of Law, where he received his JD, and he's also the class president. And please welcome my good friend Jim.
Thank you, Joel. Good morning, everybody. It's a pleasure to be here. As Joel mentioned, my name is Jim Driggs, and I am a graduate of the University of Richmond. I just graduated back in 2013, which means I'm coming up on my 2-year anniversary of practicing law. And just like many of you in the room today, I certainly have a lot to learn. But we're going to focus today's presentation on the General District Court practice. And I realize that I'm the last attorney between you and your lunch hour. So though we might be starting a couple minutes late, you've got my word, we will end on time. I think a link went out, if my understanding is correctly, that you can access a outline that created a couple weeks ago. I'm going to do my best to follow the outline, but if you've got questions through the presentation, there'll certainly be time for questions afterwards. Feel free to raise your hand. I'm a pretty informal kind of guy, and I'd much more rather this be an interactive presentation than a lecture-type presentation. The title of my presentation is General District Court Traffic and Criminal Defense for the Rookie, and I chose that title purposefully because that's what I consider myself, a rookie. And in many respects, I kind of hope I keep that mentality throughout numerous years of practicing. I think one of the worst things you can do is sort of feel like you know it all just because you've done a little bit of it in the past. But I find that if I approach each issue that I'm facing as though I'm a rookie, I'm less likely to look over a pivotal fact, look over a pivotal detail in statute or in case law, much more likely to take the case for the value that it's truly worth. Webster's defines rookie as a person who has just started a job or activity and has little experience. And I think the coolest thing about that definition is that you can be practicing law for decades upon decades and still be a rookie depending on what's right in front of you. Many of you who have been practicing in this room remember some of the excitement, some of the anxiety, maybe some of the fear you felt the very first time you had to talk to a client, or the very first time you had to go in front of a judge and argue for your client's best interest. I think that's a good thing. It keeps you on your toes, kind of keeps you accountable, and keeps you from being a little bit too complacent in the practice of law. Let's get back on track, though. The General District Court, today's agenda, I'm going to go through it briefly. We're going to talk about the general jurisdiction within the General District Court, routine cases that you're likely to have heard or will come across if you practice in the General District Court, some of the common sense issues regarding working with a client, first consultations, handling objections, answering questions, trying to predict the future where you think the case may or may not go, as well as some of the information gathering aspects of it. That may be discussing with your client how to give you a copy of their driving record, potential pleas, sentences, other outcomes. Could be discussing potential reductions in their charge, for instance. That usually leads to a little bit of research and interpretation, eventually some communication with the prosecutor, if there is one, or the court itself, deciding whether to take the case and then handling the case through trial. So that's kind of our path that I've outlined for us to go on this morning. Let's go ahead and get started. General jurisdiction. Who can tell me one matter of law that will be found in General District Court? Thanks for volunteering, Matt Anderson. Misdemeanors found in General District Court. Fair enough. Frank, you have something to say? Frank practices in federal law primarily. I should point out there are a couple of my classmates in the court, or as I was in this room today, so heckling is certainly appreciated. Keep it up. All misdemeanor offenses, most traffic matters, preliminary hearings on all felonies. That's going to be your basic jurisdiction for the General District Court. Some of the routine cases you'll find in General District Court, probably the most complex is you're driving under the influence. That's most complex simply because of the elements that need to be proved for the case to be heard, elements that need to be proved for the conviction to be found, as well as some of the discovery practices are a little bit more cumbersome regarding DUIs than other routine cases. But other routine cases might include driving unsuspended or revoked, habitual offenders, reckless driving, stopping or failure to do so at an incident, failure to report an accident, failure to find the property owner after an accident, and then a whole slew of traffic-related offenses like reckless driving, et cetera, et cetera. Let's talk about the very beginning. The case has to come from somewhere. Either a client's going to walk through your door, maybe a client's going to call your office, refer you from a past client, or it will be a past client, but overall, you need the opportunity to discuss the case with your client. Find out what their perspective is, what their view of the facts were. If it's a traffic case, your client should provide you with a copy of their driving record so that you're not caught off guard in the courtroom itself. Driving records are easy to obtain. If you go to dmvnow.com, you can pay for between $8 and $12 and get a good full version of the driving record. If it is a traffic offense, you might want to find out where the incident took place, where your driver first noticed the officer, what questions the officer asked, what responses your driver provided. Ultimately, what you're doing is kind of setting up the case in your mind, trying to figure out what issues you think there might be, as well as what outcomes you think you might be shooting for. If it's not a traffic case, then most likely it's a criminal or some sort of criminal in nature type of case. You might have the opportunity, if confident and educated enough, to talk to your client about certain pleas and what that might result in, certain sentences and outcomes, as well as provide or get a copy of the criminal record itself. That's something you can't go to your client for, but if you contact the court and make a motion for discovery, then the court will literally let you know what evidence they've got against your client. It could include the police report, a copy of the criminal history report, any statements made, any witnesses the prosecutor plans to call, but more or less they're giving you their case. So it's almost foolish of you, especially if it's a class 1 or 2 misdemeanor, not to submit a motion for discovery and at least see what the evidence is against your client before determining whether to take the case, before determining a strategy, whether you're looking for a reduction or some sort of mitigation, and determining whether to challenge the case itself, either for the stop or to suppress some evidence thereafter. Let's see, let's say it's a reckless driving case. In Virginia, you can get a reckless driving ticket in any manner of ways. Anything over 80 miles an hour could be considered reckless driving. Anything 20 miles an hour or more over the posted speed limit is reckless driving. Any type of improper driving such that you're endangering yourself or somebody else's life, limb, or safety could be considered reckless driving. Plus a number of carve-outs involving speeding or accelerating too quickly, driving in a manner such that somebody else has to react to your aggressive driving or to your behavior could be considered aggressive driving. There's lots of different ways, both speed-related and conduct-related, but let's say the Commonwealth has their case. The facts are sufficient, and if you try it, you're going to lose. So then what? What would be a good outcome, do you think? What would be a good strategy, do you think, to tackle a reckless driving case, assuming the facts are sufficient for a finding of guilt? Anybody have anything? Just spit it out. Okay, good. Driving school. So Virginia law allows a driving school, depending on what their record is. Can you say anything more about that? How clean does the record have to be, or how long does it have to be clean? Okay. Okay, all right. Good explanation, good explanation. So if you have a CDL, commercial driver's license, you're ineligible for driving school. And exactly what this gentleman said, I found to also be correct. It's not a hard, fast rule, but generally speaking, if your client's been to a court-ordered driving school in the last 5 years, they're also going to be found ineligible. Now, if you're just a couple months away, make that argument and might find a judge who woke up on the good side of the bed that day and will grant you that driving school privilege. But just like driving is a privilege, attending driving school is a privilege. The court's got their ability to defer a case out. Really, it's just a fancy term to continue the case out without making a disposition. And if your client attends a Virginia-approved driving school, an 8-hour course, some jurisdictions allow online, some jurisdictions mandate in-classroom requirement. But if it's completed and your client returns the original certificate of completion back to the court and pays the court cost, then that reckless driving ticket would be found dismissed altogether. So driving school is a really good one. Let's say they've been to driving school in the last 5 years. Still a reckless driving ticket, still facts are sufficient for a finding of guilt. Anybody have any other ideas or arguments you might shoot for? How about a reduction outside the realm of reckless driving, which is a class 1 misdemeanor? What else could it be? Improper, good job. Yeah, improper driving, defective equipment. Either one of those two charges, really good charge to try and throw out. Now think of it yourself as a judge. You've got an officer who has brought a case before you, so the officer's determined probable cause. You've got a reputation, you've got some political red tape to consider as well. Most judges are looking for a little cover. They're looking for a reason to make a decision, whether that decision is for the prosecutor or for the defense. So if you just go up in front of a judge and the facts are sufficient for a reckless driver and you say, Judge, there's really no other reason for you to grant it outside of your mercy itself, we're going to make a request anyway for defective equipment, non-moving violation, or improper driving, a traffic offense versus a criminal offense, and you haven't given the judge a reason to go with you, chances are just more likely you might not win that argument. That's all there is to it. But if you can get a speedometer calibrated, so all of a sudden the judge has a reason why defective equipment really might be plausible, or if you can sway the facts a little bit so that you can make a non-frivolous argument that improper driving might be more appropriate in the situation versus reckless driving, then you've given your judge a little cover. You've given him a reason, not just to go against the prosecutor, but you've really given him a reason to literally find in favor of the defendant, and he would be reduced down from reckless driving, class 1 misdemeanor, to improper driving or defective equipment. And you've done a great job for your client. There's all kinds of reductions, and they can go, there's some really quirky reductions that are carved out in Virginia law. I haven't used this one yet, but as you're sitting around talking during the happy hour with your colleagues, you might have heard of a case or a statute that allows for like sleeping behind the wheel. And I think I don't know if it's non-moving or moving violation, but I don't think it comes along any points on your record, and it's a good reduction, just sort of one of those crazy reductions that if no other case fits into your facts, you might talk to the prosecutor in advance, certainly, or make the argument to the judge to kind of find one of these weird carve-outs that Virginia statute has and see if the judge will go with it. Judges sort of have, and courts sort of have a way of doing things. Some judges don't give driving school whatsoever. Goochland, for instance, will give driving school, or in some instances will give driving school, but their judge literally has a calculation that depending on how fast your client was going above the speed limit, that's what their reduction off the speed limit would be. And if that gets them out of the reckless driving category, great. And if it doesn't, then great. But the judge isn't going to sway. In my opinion, I've been unsuccessful arguing for that judge to sway anything more than using his calculation itself. So one of the first things I should have said, and one of the biggest things to take home, is that all courts are a little different. All judges are a little different. All Commonwealth attorneys are a little different. And the more communication you've got, the better chances you are of representing your client with a little bit more value. Let's jump to some more substantive stuff. Let's talk about pretrial. So let's take it out of the traffic world where pretrial motions are, they're there, but they're few and far between. And let's go into the criminal world. Let's say your client was charged with a possession of marijuana, also a class 1 misdemeanor, so it's still going to be under the jurisdiction of the general district court exclusively. And you want to make a motion for discovery. Motion for discovery could wind up in any number of ways. Most jurisdictions around here have open file discovery. Raise your hand if you've heard of open file discovery. Okay. Open file discovery, just like it sounds, is that Commonwealth will literally open their file to you, whether you ask for it, whether you make a motion for discovery or not. They've got an open file discovery. Some jurisdictions make you go to the courthouse itself, like Hanover County, and you can't make any little copies of what they give you, but you can take as many notes as you want in their back room. So know what your jurisdictions are, whether the Commonwealth will literally fax or email over to you what they've got, or whether you've got to go to that court in order to get it. Aside from a motion for discovery, a motion for bond is another big pretrial motion. You should know the difference between personal recognizance bond and having to provide a secured bond, and you should have a couple avenues for helping your clients to make that decision. Bonds are pretty much about two things: flight risks versus danger to the community. So if your client's the kind of client who doesn't have the kind of criminal history, or the facts of the present charge aren't such that the court or the magistrate believes they're a danger to themselves or others, and believes that they'll reasonably show up at the next court hearing, then your client's more likely to get a recognizance or a secured bond. He's more likely to be released upon some sort of bond with some sort of conditions. But there's certain cases that there's a presumption against bond, and that means the burden shifts to the defense attorney to make a motion why bond should be provided in this case, even though there's a presumption against it. You can probably just use a little common sense and figure out what kind of charges or what kind of situations would present a situation where there'd be a presumption against bond. But can anybody spit any out for me? Murder, big one, yeah. Any kind of capital offense, presumption against bond, surely. Even if you take that down a couple levels and just simply go to assault. Assault would be a presumption against bond as well. Anybody else have any for substance against bond? Yes, ma'am. Yeah, that's right, that's right. What was that big gun control act that you always hear about? What is it? The Brady Bill? That might have been related. That's not what's on the tip of my tongue, and I just can't articulate. But about being a felon with a firearm? Project Exile, that's exactly what was on the tip of my tongue. Yeah, Project Exile. All right, excellent. You're also going to have the opportunity during trial to counter your police officer or counter the person who's going against you. I recommend taking an aggressive approach. Police officers are just there doing their job. They might not even remember the facts personally, but they've got their police report that they can refer to. The more holes you can punch, even if you're just slinging mud against the wall, the more holes you can punch in that police report or in the cop's testimony, even if it's not dispositive, meaning it doesn't win you the case with what your current action are, it might set you up for a larger argument in the future. And eventually, if you punch enough holes in the Commonwealth's case, the judge should rule in your favor, whether it's a complete dismissal or a reduction, but you're doing a better, providing more value to your clients itself. Anybody have any questions about other motions, discovery, motions for null pros, motions to strike, other motions that you commonly find in the general district court trial setting? All right. Let's talk a little bit about then some more specifics. DUI, I mentioned earlier, is one of the more complicated cases to handle, and a lot of it has to do with the procedure, practices and procedure in the DUI itself. So you've heard all probably kinds of law against the certificate of analysis. Very formal, very procedural driven types of analysis that either prove your client had breath that showed too much blood, or had blood or alcohol, or had blood that showed too much alcohol itself. But there's a lot of new case law in Virginia that determines when a certificate of analysis can be admissible and when it can't be admissible. First off, you gotta understand the implied consent law in Virginia. I should have, section 18.2-268.2. And implied consent basically says that because you have a privilege of driving on a public highway, you are automatically consent to providing blood or breath to the Commonwealth, to the police officer. But in many instances, that implied consent can be challenged. For instance, I mentioned you've got to be on a highway. There's case law that tells you what is a highway, public roadway, and what is not. And a lot of times these stops are done on non-highway type of locations, like 7-Eleven parking lot or like convenience store parking lots. And there's a case called Privilin versus Commonwealth in 1957 that says gas stations are not determined to be a public highway. 7-Elevens was further determined not to be a public highway for habitual offender users. Sporting goods stores, parking lots, not considered a public highway. And apartment complexes was considered a highway for implied consent reasons only. But case law pretty much drives a lot of the analysis behind what could be admitted, what could not be admitted into evidence. And then that typically leads to refusal. A refusal would simply be if somebody refused to give blood or refused to provide their breath test to the officer. Refusal is a Class 2 misdemeanor. A driver's license could be suspended for up to 3 years if there is a previous refusal within 10 years of the present refusal you're dealing with. So you need to know what the past criminal history as well as what the facts surrounding those criminal histories were in instances of a refusal. Just one second. A great thing to know before I do open the floor up just for a couple questions is that the court always has the ability to take a case under advisement. So if facts are against you and the law is against you and you really don't have a whole lot else going for you, sort of the catch-all or maybe last resort argument that can always be made in front of the judge is an argument based on Hernandez versus Commonwealth in 2011. And that allows, as long as the judge hasn't made a disposition, hasn't ruled on a case yet, that judge can defer it out for a period of time, allow that defendant to forego some education, do some community service, jump through certain hoops while the case is deferred, then bring it back before the court and make a ruling then, whatever it might be. So a lot of times the prosecutor might not see it coming because it's a relatively recent case of 2011. Prosecutor might not think you got any ammunition in the old tool bag, but you always have Hernandez versus Commonwealth that you can argue for a deferred disposition. How about after the case? We talked a little bit about the trial. We talked a little bit about methods for asking questions and cross-examining police officers after the case, whether you win or lose. Let's say if you win, there's not going to be a whole lot else unless the Commonwealth decides to appeal, certainly an opportunity. But let's say you lose the case and your client's not happy with the outcome. How long do you have to make a motion to reopen? 30 days? 60 days. 60 days in a criminal case. Appreciate you speaking up nonetheless. 60 days to make a motion to reopen. How long to appeal? 10 days, right on. Other than that, I don't think there's a whole lot of post-trial motions or post-trial activity you could have aside from answering questions related to the sentence itself, maybe helping your client negotiate some ASAP kind of violations, things along those lines. Let's talk, I said I was going to open it up for questions, and I will, but you should sort of know the process of DUI. Did you know there's a 7-day statutory loss of license provision? So you get a DUI, no matter what, you're going to lose your license for 7 days. And then it ideally will get sent to your client in the mail. And if it doesn't, on the 7th day, your client can go to the local jurisdiction and request their license and will be given back their license. So even a first offender DUI will lose their license for 7 days before they'll get it back and can then drive until the case is heard. But I didn't realize that coming right out of law school. Certainly didn't realize that on my first, the first DUI that I defended. Yes, ma'am. Before the disposition. It's an authoritative loss of license. Yep, yep. So loss of license, but they get it back in 7 days. Generally speaking, then you go, to have your arraignment, but eventually you'll make your way to trial. Trial itself, let's say they're found guilty of DUI. What's the mandatory minimum fine for a DUI conviction? Anybody know? $250, that's exactly right. How about mandatory mandatory implementation of a suspended license? How long? 12 months? That's right, 1 year. How long, or can you ask the judge for a restricted license? Generally speaking, yes. What do you got, Matt? Fair enough. Generally speaking, at least make the request for a restricted license. If the situation doesn't provide it, or if you've got a habitual offender on your case who has DUIs in the past, they might get shot down, but make the request. So then the court will literally give you a piece of green paper that outlines the scope of your restrictions. That's not your restricted license, and that doesn't give you the privilege to drive. And I've had more than one defendant take that and think they're okay to drive as long as they're within the scope of their restrictions, and then all of a sudden they get pulled over and get a ticket for driving under suspended license. And it's non-frivolous, it's sufficiency of the evidence, it's good to go. They've got to take that green piece of paper and complete their ASAP. When I say completed, that's I misspoke. They have to register for their ASAP. But once they get a piece of paper that says they're successfully registered for ASAP, and they have the green piece of paper said they're eligible from the court's perspective for a restricted license, then they literally go to DMV itself, turn in those pieces of paper or copies thereof, and the DMV will give them a hard copy driver's license, just like we've all got in our pocket, but it'll have the word restricted stamped on it. And only then can they actually operate lawfully under their restricted license. A lot of people don't realize that process, end up getting themselves in trouble, and then it's up for great attorneys like us to make an argument why the driving on suspended license should not be what is a conviction afterwards. But save your client from having to make that argument, having to pay you more money to make that argument for them. Let them know the process up front. How about interlock? It's mandatory. Whether it's a DUI first offense, DUI second offense, third offense, it's either going to just get more and more burdensome for your client. What people don't realize, though, is that though you've got your interlock for the entire year of your suspended driver's license or restricted status, you can request it to be removed after 6 months. It's got to be proactive. You've got to do it on your own, or have your client's got to have your attorney do it. Yes, ma'am. It is, I'm sorry, yeah, it means you have to blow into a machine in order for your car to actually start. It is, it's mandatory now. Yep, that's exactly right. But you can ask the court to remove it after 6 months, certainly something to do so that you can benefit your client a little bit longer. Okay. Any other questions about DUI itself? Yes, sir.
Would the court make you do that for all the cars that you have when you're
That's a good question. I don't really know, to be honest with you. Yeah.
So when you avail yourselves of the highway, and you were in the parking lot of a sporting goods store or a gas station, do you need to have just been on the highway? I mean, is that what matters, or is it being in the parking lot at the time the police officer asks
I think it's going to come up, that's going to be argumentative. But obviously, the officer is going to say that he saw you when you were driving the car. And operating means that the car is not only just on and the key is on, but the car is actually also in motion, is the definition of operating the vehicle. So the officer is going to say that. Your argument would certainly be that you were just in the parking lot itself and that you weren't actually on the public highway. And it really is going to be fact dependent on that situation, I would list.
So if you're on a highway and the blue lights come on, and
Behind the highway and you pull off, you're probably going to lose that argument. Yeah. Can you repeat a little bit louder your first question? If you own more than one car, how many vehicles do you have to put the ignition interlock system on? I know there's costs associated with the interlock system. I think, yeah, and I don't know if you can take that machine out and put it in the next car. Is it easy? I figured it was more like bolted into the car itself, respectfully speaking. Okay, will you say it a little bit louder?
It's the second offense and has to go on every car registered in your name.
Okay.
The first offense is
Just the primary vehicle, what you might declare your primary vehicle? Your C. Okay. Okay. Good. All good discussion. All good discussion. Any other questions about DUI or stopping in general? Let's talk about field sobriety tests then, just because they can be a little bit exciting. But what type of field sobriety test have you all encountered in your practice? There's a couple that I seem to get time and time again. One of them being the alphabet test, where the officer will literally pick one letter at the beginning of the alphabet, one letter at the end of the alphabet, and either make them go forward or backward. And I'm not saying admissible or not. In fact, most of them are not admissible. But have you all experienced that in your practice before? That specific FST? Yeah, only forward? Okay, only from moving forward. What other field sobriety tests have you encountered? Walk and turn? Yeah, that's always a good one. Horizontal gaze test? Finger to nose? Are they still doing that one? I haven't come across that one recently. Okay. And then recitation of the alphabet. The defendant's refusal to submit to the field sobriety test is not evidence itself or consciousness of guilt. However, the refusal may have some relevance in a police officer's assessment of probable cause for arrest. When other facts indicate the driver may have consumed alcohol or drugs, the refusal to perform the field sobriety test is circumstantial evidence, tending to show the driver's awareness that his consumption of alcohol would affect his ability to perform such tests. And that's the case Jones v. Commonwealth, 2008. Circumstantial evidence I hear from prosecutors all the time. Underage drinking at a house party, for instance, and the cop didn't see the person holding a beer, and the person refused the breath test, but got an underage drinking simply because they were around other people who were holding beers and who did submit to the breath test. And they got the conviction, took it to trial, and ended up being victorious. But the prosecutors, their main argument was that they was circumstantial in nature. So the fact that the client had bloodshot eyes and the fact that the officer said the client had slurred speech, coupled with the fact that he was at a house party, led the judge and the prosecutor's argument would lead a court to believe that reasonable doubt was satisfied. And we argued it, made a motion to strike, lost the motion to strike, actually had to present evidence. And it was only because we had another excuse for the bloodshot eyes and the slurred speech that we won that argument, and ultimately the case was dropped completely. And that was simply because the client had a prescription medication for Xanax or whatever, Adderall, whatever those were, and two of the side effects were slurred speech and bloodshot eyes. Anybody have a question about that? Got a bunch of cases that I cite, that I pulled off just to kind of see where law was presently. But from a substantive standpoint, that's my presentation on both criminal practice as well as traffic court practice. I think the most important thing that you could take away is communication, is don't just wait till the day of trial to try and work out some favorable outcome with your client, but go and meet with the prosecutor. And certainly the more severe the charge, the more important it is to go and meet with the prosecutor in advance. I've had lots of prosecutors tell me that they just appreciate a little proactiveness in meeting a week before or a couple days before trial, so that I wasn't one of those attorneys standing in line waiting to meet them on the day of trial itself. Of course, if it's just a routine case, first offender status eligible, and there's really no question about what's going to happen, then maybe don't waste your time. It's a more of a strategy, practicality kind of analysis at that point. Any questions for me then about the process? Anything from getting the client to the beginning, going across through the first client meeting, arraignments, pretrial motions, trial itself, post-trial motions, or I've got a lot of good case law I mentioned that talks more specifics about field sobriety test, refusals, implied consent, stops, seizures. I mean, all the stuff that we remember from first, second, and third year of law school. Sorry, in the back.
Pleadings, when you want to offer evidence and mitigation for a traffic offense or a criminal offense, but you're not arguing the facts, you still plead not guilty, correct? Because you don't want judgment entered against your client immediately.
So if your argument is basically for sentencing, but the facts are sufficient,
Or reduction of the charge.
and you just simply want to preserve your ability to make that argument. So thinking that if you plead guilty or plead no contest, you're not going to have the ability to make the argument. I think in general district court, because it's such an informal court, in my experience, the judges are going to hear what you got to say. Whether you plead guilty, not guilty, or no contest, if you say a little sentence like judge respectfully requests to say a couple words pertaining to sentencing, you're not going to walk out of that courtroom not having the opportunity to be heard. That's a great thing about general district court. Some people would say it's an advantage, some people say it's a disadvantage, but it is an informal court. You don't have to base your arguments on a whole lot of case law and a whole lot of statutes. Your arguments can be more conjecture or, basic theories that you kind of halfway remember from law school. The judge will hear it, the judge will consider it, and really the judge will, most of the time, give your clients a fair disposition. So the other courts, like circuit court, they're much more procedural driven. Certainly federal district court, which I don't have much practice in, but I am admitted to, things like procedure and process are much more important. General district court's kind of a heyday. Just make the argument and pray. Yeah, buddy. Sure, they could. Yeah, it's never happened to me, and probably less likely than the defendant appealing, but I don't think there's anything. Does anybody know of any reason the Commonwealth could not appeal? They cannot appeal. But not the case itself? They couldn't take a GDC up to circuit on an appeal? Really? Okay, I stand corrected. I apologize.
They can appeal some procedural issues.
Okay. So, but procedural only, not the disposition itself?
I don't remember.
A bond, right. Okay, fair enough. Do you see that often? Something that's way out there? Yeah. Sure. Oh, you think so? Just because of presumption the Commonwealth might take the appeal just because of the, okay. Is what it is. Any other questions for me? I'm 15 minutes early. Let's ask a couple more questions, and then I'll definitely release you early. Yeah, yeah. Toll cases, okay. So my firm handles the toll collection cases around town. We've got both RMA, which is Powhite Parkway, as well as like courthouse, that little 25-cent toll in courthouse. And we also have Interstate 895, which is run by an LLC called Transurban. Toll collection is tried as a civil case, so I'm kind of going outside the world of criminal traffic presentation. It's tried as a civil case, but it's considered a traffic infraction. And why they do that is to allow a violation to be reported back to DMV, so that eventually your license could become suspended solely because you haven't paid tolls in the past. Here's what most people don't know, and you should really check out the statute. Toll collection ratchets up super high, super quick. So if you got one violation, chances are nothing's going to happen. Although statute allows a $50 penalty and a $100 administration fee. 2 violations in a given year, and it jumps up to like a $150 penalty, still a $100 administration fee. 300 violations in a given year is $250 penalty, still a $100 administration fee. 4 or more violations a year is something like $500 for each violation, plus a $100 administration fee. So when I do the toll docket once a month, we typically have about 150 defendants. Only like 10% of them actually show up. But I see cases involving toll penalties where people have run the toll any number of 3 to 70 times within the last given year. And the principal balance, I mean, I've seen over $100,000, and that's not at all what I consider uncommon. So think about it, you run the toll 16 times in a year, and all of a sudden you get a warrant, more or less a warrant in debt, summons for your arrest, and it claims $60,000 in principal balance, $16.25 $16.25 principal balance, $60,000 civil penalty, $100 administration fee, plus the attorney's fees, and you're like, whoa, it gets real high real quick. The 1-year statute of limitations is not in statute. It was just heard by a Fairfax Circuit Court judge earlier this year. So before that ruling, we were seeing cases being brought for violations up to the last 3 to 5 years, but now we've had to funnel it down to 1 year. Sir? Well, here's how the process works. You run the toll allegedly. They get a photo of your driver's license. So what we're talking about is not the toll lane where you come up, stop, and pay manually. We're talking about the high occupancy vehicle lane where most people have an easy pass and you just fly right through. They'll take a picture of your license plate and they'll send the warrant itself to whoever is the registered owner of the license plate according to DMV. So a lot of people have the defense right off the bat, they weren't driving. They weren't the driver. Their sister, their brother, their friend, whatever was the driver. On the back of the warrant, they then have to rat out whoever the driver was. They have to provide that person's information and the case will be brought against the right person. But ultimately, they check their DMV records. That's where the warrant gets sent to. And then if you pay it in the first 30 days, the admin fee can only be $25. That's it. But if you fail to pay it in the first 30 days, and then the case eventually gets turned over to our office, and then that's when the civil penalty ratchets up. What we do is we always get to court an hour and a half in advance, just to try and intersect everybody we can on that docket before they actually walk into the courtroom itself. Because though it's not in statute itself, most courts interpret the civil penalty to not attach until you enter the courtroom itself. So if we can work out a deal and you just pay the principal balance and the administration fee before either of us walk into court, then I've got that authority to do so and the courts will roll with it. But I'm in Richmond General District and Circuit for the Powhite Parkway RMA cases, and then I'm in Henrico General District and Circuit for the Transurban 895 cases. Any other questions about tolls? It's an interesting beast. Not many people realize it. Without looking twice. Judge Stevenson, Judge Malvo, Judge Chucker, and Henrico. It's statute, and it literally says the court shall impose, so they don't have any discretion over it either. Yeah, principal balance and the administration fee. And I'll continue their case. I'll take installment payments. Our office is a big debt collecting office. We do a lot of civil litigation as well, so we've got all those processes set up. Yep. Interesting beast. Yes, ma'am? Let me answer the first question first. I think there's a 3-hour presumption that the arrest has to take place within 3 hours of the blood or breath, or the burden might shift, or even the evidence found not admissible. But to answer the first question, I think you've got to show good cause for why the breath can't be given, whether you're sick or coughing, or they can't get the 20-minute observation period before the breath, whatever it might be. And then it's up to the officer. I don't think there's a duty for him to give you the blood, but it's up for the officer to choose whether to go blood if they determine your reason is satisfactory for not giving breath. A lot of times breath's a lot easier and they can do it right there on the spot. They don't have to drag you to the hospital, so they're going to do everything they can to get the breath from you. But if you're coughing, sneezing, and interrupt that 20-minute period, then they could resort to the other options. But you always have the ability to refuse. It's just what happens after that. It used to just be a 6-month suspended license, I believe, but now it's actually a Class 2 misdemeanor if you've done it before, done it in the past 10 years. Class 1 misdemeanor? I'm sorry. It's suspended license for a year, eligible for restricted as long as all the facts are okay. Got to have the interlock system as well. Yeah, that's a good one.
What's the style of that case with the 1-year statute of limitations?
Yeah. Yeah, Commonwealth versus Cooley. Anything I've gone over, I'm happy to make copies of, whether any case I've spat out or this opinion letter I just gave the gentleman, happy to do so. I can email you or get Joel to email you, however you want to handle it. Okay, hey, it's 12:07. That means you're getting out roughly 7 or 8 minutes early for lunch. You're welcome. Thank you for letting me be here today.